Hello, everyone. Thank you for joining another episode of Honeycomb Digital Investments, the Regulatory Buzz. Today is November 8th, 2022. Got a lot unfolding in the marketplace and the headlines, and I am delighted to be here again with Professor Carol Goforth at the University of Arkansas. Hello, Carol.
Hi, Baxter. How are you doing?
Doing really good, despite all of the excitement. I thought today was going to all be about the elections that were taking place throughout the country, but crypto headlines are almost overtaking that news feed. It's
indeed, another busy day.
What a busy day indeed. So wanted to talk with you about one of the news stories that's having a lot of impact from a regulatory standpoint on the marketplace, and that has to do with LBRY, or the LBRY token. LBRY is a decentralized media and file sharing service, and there was a lawsuit that was filed back in March of 2021 that now a New Hampshire-based federal court has made a ruling on that probably is going to make some waves in determining what is a security and what is not a security in the digital space. If you would, maybe just give us a high-level idea of what's going on here.
Sure. You're absolutely right. This is a federal decision out of the district court from New Hampshire, where the SEC filed a motion for summary judgment saying, as a matter of law, these tokens should be classified as securities. There were really only two arguments that were raised by the issuer of the token. One, which is also raised in the Ripple case, is we didn't have fair notice that this was going to be regulated as a security. And the other issue was whether or not, in fact, this should be, as a matter of law, classified as a security under Howey. Now, the fair notice issue, I think, is a little bit different for the LBRY case because, according to the court, LBRY conceded that they knew that Howey was the test that was going to apply. They just didn't know it was going to apply to them because all preceding cases had involved ICOs, initial coin offerings, and theirs was a continuous, gradual dissemination of coins, a lot like Ripple had done. But by the very act of saying that we are only arguing whether or not we knew that this was going to apply to things that weren't ICOs, I think that distinguishes the LBRY case from the XRP case, because XRP tokens were being sold way before the SEC ever said we're going to use Howey to figure out whether or not we have a security or not. So I think for the fair notice claim, I think that is still a valid argument for Ripple to be making on behalf of all of its XRP tokens. Now, the heart of the case was the determination by the trial court that as a matter of law, the LBRY tokens are securities. And I think the really important thing about this case is the insight that you can gain by looking at what the SEC alleged and what the judge focuses on in its opinion. And that is just how much the company, the promoter, LBRY, said you can make money, you can make profits. This is an investment. If you put your money in early, we are right with you. We're all in this together. There is money to be made. And it is true that, as LBRY points out in its response brief, that, well, if you look at all of our tweets, all of our posts, all of our communications, less than 0.25% of them had information about the profitability. But the judge's response is, yeah, but you don't tell us how often you disclaimed, how often you said it's only for consumption or it's primarily for consumption. Of course, you're going to have lots of other comments that have nothing to do with the token at all. They have to do with your business model. They have to do with, transaction times. They have to do with the content that's being posted. They have to do with some other topic entirely. And if you wanted to convince us that really you were not marketing this as a security, you were not marketing it as a speculative investment, you needed to show us that most of your communications to potential purchasers were not for investment, and you didn't do that. I think if you take a look at that approach from the complaint, that approach from the judge, and then you go back and you look at that recent Coinbase insider trading case, where the SEC decided to say, here we have these insider traders, these folks who knew that Coinbase was going to list these crypto assets before they were listed, assumed that that would create a bump in the price, and they traded on that inside information. And they did it for 25 different assets. We know they did it for 25 different assets because the Department of Justice brought a mail fraud and a wire fraud case against them for the criminal violation of those laws. The SEC, on top of that, brings a civil action only against 9 of the 25 assets that they were identified as having traded. Why those 9 assets? The SEC doesn't tell us why, but if you read through that voluminous complaint, every single one of them had a pattern where the creator of that token marketed it as a speculative investment. It is for profit. It is to make a profit. It will make you rich. It will make money. You'll be in this with us. Our fortunes will rise together. And that turns out to be what I think is the critical element of the Howey analysis. And it is so tempting to say, well, let's look at what the SEC says it's going to do. Back in 2019, we have statements from Bill Hinman, then the director of enforcement, and from Jay Clayton, the then director, that talk about decentralization. And so we have all of this speculation. Oh, the important thing is how decentralized it is. But if you stop listening to just the talk and watch what they are actually doing, how are they walking this to the courts, they are not talking about decentralization. They are talking about how the issuer markets these assets. And I think that could be potentially huge for future creators and issuers. And a huge lesson to learn is don't market this as a speculative investment. Market it as something with utility. Market it for consumption. Market it as something other than an investment where you stand to make a profit along with the creator. Because I'm not seeing enforcement actions being filed without that pattern of marketing. And I think that's huge.
And Carol, what kind of fines and repercussions are we talking that Liberty is going to have because the SEC has ruled or is determined, or the court has determined that this is a security?
We really don't know what the eventual consequence of this is going to be. We don't know if there'll finally be an order that settles this. We don't know if there's going to be an appeal. We don't know the ultimate resolution. I think we saw a tweet from Liberty shortly after the opinion was announced saying something akin to, we're going to go lick our wounds now for a while, but this isn't the end. We'll be back. And what that means, your guess is as good as mine.
Gotcha. Well, it sounds like this could spill over into some of the other proof of stake in particular protocols. And Ethereum has always been looked at as sort of in the clear with Bitcoin. I shouldn't say as always, but generally the market has kind of grouped those two as in the sort of the safe zone, and the other altcoins are really the only ones that could be hurt from this. What is your take after this latest ruling?
Yeah, that's a really great question. I think the reason that the market was so willing to group Ether in with Bitcoin is traceable back to, again, Bill Hinman, who specifically said, I don't think Bitcoin is a security, and I don't think Ether is, because they are too decentralized. If we move away from the question of decentralization, then I think the issue of what is the Ethereum Foundation, what are the folks who are driving decisions on the Ethereum network, such as the decision to move to proof of stake, and forcing that on the community with things like the difficulty bombs that make mining much less viable or attractive as a way of incentivizing validation. I think There is more of an argument now that maybe that will actually move Ethereum out of the completely safe zone. You sort of see hints of that in some of the things that Gensler is saying, which is that proof of stake systems, in his opinion, could very well and should be treated as securities. And again, I think it's reflective of a move away from the question of how decentralized is ownership. Again, it's a matter of how is it marketed? How are you incentivized? Are you making profits together? Is that how we get you into the staking pools? And I think that may indeed create problems. I'm not sure it should, but the SEC certainly has that option open to it.
Mm-hmm. Well, as we said at the beginning of this filming, it's a lot going on, and I really appreciate you being here today to talk about another important case and another important just instance of where this whole, is it a security or not a security, is coming to the forefront. So we thank you for being here and look forward to seeing you again on another episode of the Regulatory Buzz.
It will be my pleasure.
See you soon, Carol.
Bye-bye.